Regulation 39 is about issuance of certificates or receipts or letters or advices for securities and dealing with unclaimed securities. Now, in case of such letters or advices to be issued, the companies need to comply with Rule 19(3) of the Securities Contracts Regulations rules, and in case of issue of share certificates, in case they are lodged for subdivision, split, consolidation, renewal, etc., they need to be issued within 30 days. So now for any issue of duplicate share certificates, it has to be complied with within a period of 30 days, even when Companies Act provides for a longer duration. Where there is information about loss of share certificates and issue of duplicate share certificates to the stock exchanges, it needs to be informed within 2 working days of getting such information. So companies need to coordinate with the share transfer agents where such information has to be complied with and provided to the stock exchanges. In case of unclaimed shares, this requirement was introduced in 2012. In case the share certificates were returned undelivered out of public issue or rights issue, the companies were required to provide 3 reminders to such shareholders, and then such shares which were still not claimed were transferred to unclaimed suspense account, and the voting rights on these shares are frozen as such. If you would see, the Companies Act under section 124 also provides that where the dividend is unpaid for a continuous period of 7 years, the corresponding shares shall be transferred to IEPF. While there is also a provision under listing regulations which says that the companies will comply with the requirements of Companies Act, in the first year of its introduction, there is still no clarity as to how exactly this has to be implemented, and where there is overlap, how it has to be sorted out. Regulation 40 is about transfer or transmission or transposition of securities, which basically states that the transfer of shares shall be attended by the board or the delegated authority at least once in a fortnight. So every 15 days, the board or the share transfer agents need to confirm with the requirement of share transfers. The delegated authorities, that is the share transfer agent, should provide the report on transfer of shares to the board of directors of the company. Thus, the share transfer agent or the company has to register the transfer of shares within a period of 15 days from the date of receipt of request or raise a valid objection. In case of transmission, it has to be processed within a period of 7 days if it is under a dematerialized mode, or within a period of 21 days if it is in the physical mode after receipt of the specified documents. No transfer can be processed if the transferor objects and serves within 60 working days a prohibitionary order of the court or tribunal. The procedural requirements for the transfer and transmission have been specified in Schedule 7. If the transfer is not processed or no valid objection is raised within the stipulated time period of 15 days, the listed entity shall compensate the aggrieved party for the opportunity losses caused during the period of delay. So if the company fails to register the transfer and if the share price goes up during this period, the party can claim losses for such opportunity lost during the period of delay. The companies as a compliance need to obtain a certificate from the practicing company secretary within 1 month of end of each half year, where the practicing company secretary shall certify that all certificates have been issued within a period of 30 days from the date of lodgement for transfer, subdivision, consolidation, renewal, or in case of exchange or endorsement of calls or allotment of monies. Such certificate received from the practicing company secretaries has to be filed with the stock exchanges by the listed entities. About other provisions relating to securities, where the listed entities shall not exercise a lien on its fully paid shares or amount to be paid in advance on calls. Any advance on calls may carry interest but shall not in respect thereof confer a right to dividend or to participate in profits. So, any advance on calls can have interest payable thereon, but will not have entitlement to the dividend declared by the company. The company shall not issue shares in any manner which may confer on any person superior rights as to voting or dividend vis-a-vis rights on equity shares that have already been listed. Any issue, offer, rights, privileges, redemption or any terms of issue shall be on pro rata basis unless specified separately. Is about record date or date of closure of transfer books. There are certain specified events for which the company may opt for record date, or in case of shares held in physical, a closure of transfer books. It will be in case of declaration of dividend, issue of right or bonus shares, issue of shares for conversion of debentures or any other convertible securities, or shares arising out of rights attached to debentures or any other convertible securities, or in case of corporate actions like mergers, demergers, split or bonus, etc. In such cases, the company has to determine a record date for considering or for identifying the eligibility of the shareholders for such matters. Where the record date is determined, advance notice of at least 7 working days, that is excluding the date of intimation and such record date, has to be issued to the stock exchanges. For dividends, the companies need to ensure that they can be recommended or declared at least 5 working days excluding the date of intimation and the record date before the record date fixed for the purpose. Now friends, we need to understand the timelines for certain separate matters issued under different regulations. So in case of dividends or cash bonuses, the company needs to inform the stock exchanges at least 2 working days in advance of the date of board meeting. Whereas for the record date, it has to be at least 7 working days in advance, and a notice of 5 working days also is required before such recommendation of dividend. So all these timelines need to be considered in case of declaration of dividend or cash bonuses. For securities held in physical form, the companies can opt for book closure, which is also prescribed under Section 91 of the Companies Act. It's important to ensure that the time gap between the 2 record dates or such closure of transfer books is at least 30 days. 3 provides that in case of dividends, the dividends will be disclosed on per share basis, and the company shall not forfeit unclaimed dividends before the claim becomes barred by law. Now, why it is provided that it shall be per share basis is the companies may have different face values. So, a company who has 10 rupees face value and issuing a 20% dividend will pay 2 rupees on its shares, whereas a company having a 5 rupees face value and issuing 20% dividend shall only pay 1 rupee per share. That is why for the shareholders to understand what is the dividend receivable on such shares, it is important to announce the dividend on a per share basis. The company shall not forfeit such unclaimed shares unless barred by law, or that is as per the IPF rules. SEBI introduced Regulation 43A in July 2016, which states that the top 500 listed entities as per market capitalization shall have a dividend distribution policy. This policy shall be placed on the website and also disclosed in the annual report. While it is mandatory for the top 500 listed entities, other entities can also follow this on a voluntary basis. What needs to be included or what parameters to be followed in the dividend distribution policy have been prescribed in the regulation, and accordingly the companies can frame their dividend distribution policy. 4 is about voting by shareholders, which provides that the entity shall provide for e-voting to all the shareholders as per the Companies Act Rules 2014. This requirement earlier had certain discrepancies between what was stated in the listing agreement and the Companies Act rules. Now it has been synchronized, and hence the e-voting facility has to be provided in accordance with the Companies Act rules. The listed entities have to submit the voting results within 48 hours from the conclusion of the meeting, and the entities shall provide a proxy form to all the shareholders with an option to vote either in favor or against each resolution. 45 is about change in name of the listed entity. So if the listed company has changed its activities which are not reflected in its name, it shall be required to change the name in line with its activities within a period of 6 months from the date of change of such activities, and such name change shall be in accordance with the Companies Act 2013. Every listed entity is required to maintain a functional website, and there are certain informations which are provided to be uploaded and to be made available on the website of the company. Company's website is the first phase of the company for giving the initial information, including the details of board of directors, various committees, its shareholding pattern, or the policies which are required to be uploaded under the regulations. So all this information has to be available on the website at any given point of time, and if there are any contents to be uploaded or updated, they have to be updated within 2 working days. 47 is about newspaper publications by listed entities. It essentially provides that the company shall publish in newspapers 1. Notice of board meeting where financial results shall be discussed. So this is a quarterly requirement applicable for all the listed entities. In case the financial results, then they have to be published within 48 hours of the conclusion of the meeting. The statement of variation of funds, which we checked in regulation 32, also has to be published, and any other notice issued to the shareholders by way of advertisement shall be published in the newspapers. Whenever the newspaper advertisements are to be published, the link of the website of the entity and of the stock exchanges where the financial results are being uploaded needs to be included in such advertisements. This advertisement shall be published in at least one English language national daily and in one daily newspaper published in the language of the region where the registered office of the listed entity is situated. Now in Companies Act, we have seen there are certain requirements which state that the language of the newspaper has to be the principal language of the district or the region in which the registered office of the entity is situated. Say for example, the notice for e-voting or the notice in case of change of registered office, it has to be published in not only the English language but also in the regional language of the place where the registered office is situated. Against the requirement in listing regulations, the language of the newspaper publication has to be English, but the publication has to be made in the English daily as well as the regional daily of the state or of the region in which the registered office is situated. This requirement is however not applicable in case of securities listed on the SME exchange. Such newspaper publication shall be made at least in one English language national daily newspaper and in one daily newspaper published in the language of the region where registered office of the listed entity is situated. So here only the language of the newspaper has been specified, as it has to be English in case of national daily and the regional language in case of regional daily. In case of Companies Act, you would have seen that there are cases where the newspaper advertisement has to be published in the English daily, which is national daily, and in case of regional daily, it has to be published in the principal language of the region where the registered office of the entity is situated. Say for example, in case of notice for e-voting, it will be published in the English language for the national daily. However, in case of state of Maharashtra, it will be in Marathi in the Marathi newspaper, or in case of state of Karnataka, it will be in Kannada language in case of Kannada newspaper. This requirement is not applicable in case of specified securities listed on the SME exchange. Comply with the applicable accounting standards. So now we see that the Ind AS is phasing in, and there are certain entities which are falling in the applicability of Ind AS. So whichever accounting standards are applicable for the entities, they need to comply with the same is what is the requirement under this regulation.